Hi, welcome to our channel of IGNOU Audiobooks, Indira Gandhi National Open University, School of Law, SOL, Postgraduate Diploma in Criminal Justice, PGDCJ. MLE 011 Criminal Justice System. Block -1 Basic Issues. Unit-2 Approaches to Crime, 2.1 Introduction. Crime is a relative concept and a changing one too. Approaches to crime have been different at different stages of human civilization and even at a given time. They have been different in various societies. The attitude towards crime has always been marked by extreme type of emotions displayed by society and its people. What constitutes crime varies from culture to culture and from time to time. Traditional approach defines crime in terms of violation of public law, whereas modern approach to crime emphasizes upon functional aspect of law. Theoretical explanation to crime involves individualistic and environmental approaches to crime, beginning with the pre-classical approach of demonological theory to the extremely plausible theories based on socio-economic factors at the other end. The study of different approaches to crime makes it clear that it is not possible to lay down all the causes of crime which will give foolproof answers to all questions of crime causation in general. Different types of offenses have different kinds of motivations and all of them cannot be explained by the same approach. In this unit we will not only explain traditional approach to crime but also modern approach to crime including theoretical, punitive, therapeutic and preventive approaches to crime. 2.2 Objectives. After reading this unit, you should be able to assess the meaning of crime, examine various approaches to crime, analyze usefulness of understanding approaches to crime, identify policy issues with regard to crime and criminals, describe lacunas in existing policies dealing with crime, and suggest policy reforms for dealing with crime. 2.3 Traditional approach to crime. To understand approaches to crime, it is necessary to understand crime. Etymologically speaking, the word crime originates from the Latin crimen, genitive, criminus, from the root of Latin cerno equals I decide, I give judgment, and Greek neu equals I judge. Originally the Latin word crimen meant charge. In law, guilt, accusation. Ernest Klein, citing Carl Bergman, suggests crimen, which would originally have meant cry of distress. Some people regard the definitional problem as the most important task in criminology for deciding the criminal policy. Some of the most common definitional approaches area crime may be an act of disobedience to a law forbidding or commanding it. But disobedience to civil law may not be a crime, for instance disobedience of civil laws or laws of inheritance or contracts. Therefore a crime would mean something more than a mere disobedience of law. It means an act which is both forbidden by law and revolting to the moral sentiments of the society. Robbery or murder would be crime because they are revolting to the moral sentiments of the society. Then again, moral sentiments of the society is a flexible term as it changes from time to time with the growth of public opinion and the social necessities of time. It may also differ from country to country. Adultery, incest, sati, female feticide, polygamy etc. are not crime in every legal system of the world. It means content of crime changes from time to time in the same country, and from country to country at the same time. A virtue of yesterday may become crime tomorrow or vice versa. All efforts to define crime beginning with Blackstone down to Kenny in modern times has proved abortive. Russell observes that to define crime is a task which, so far has not been satisfactorily accomplished by any writer. In fact, criminal offenses are basically the creation of the criminal policy adopted from time to time by those sections of the community who are powerful or astute enough to safeguard their own security and comfort by causing the sovereign power in the state to repress conduct which they feel may endanger their position. Crime needs to be defined in the true sense of the term, which gives the whole thing and the sole thing true of every crime and yet not to be true of any other conceivable non-criminal breach of law. Crime may be defined in terms of its attributes and characteristics by first distinguishing crime from civil and moral wrong, and secondly by critically examining definitions given by eminent criminal jurists from time to time. Distinction between moral, civil and criminal wrongs. There are certain acts which a large majority of civilized people in the society look upon with approbation as they tend to reduce the sum total of human happiness. Such acts as lying, gambling, cheating, stealing, homicide, proxying in the class, gluttony etc. are wrongs. Some of these wrongs are not serious enough as to attract the notice of law. We only disapprove of them. Such wrongs may be designated as moral wrongs, for instance, lying, overeating, disobedience of parents or teachers and so on. Moral wrongs are restrained and corrected by social laws and the laws of religion. There are other wrongs which are serious enough to attract the notice of the law. The reaction in the society is grave enough and is expressed either by infliction of some pain on the wrongdoer or by calling upon him to make good the laws to the wrong person. In other words, law either awards punishment or damages according to the gravity of the wrong done. If the law awards a punishment for the wrong done, we call it a crime, but if law does not consider it serious enough to award a punishment and allows only indemnification or damage, we call such wrong as a civil wrong or tort. Definitions of crime. Sir William Blackstone in his classical work, Commentaries on the Laws of England, Volume 4 defines crime as an act committed or omitted in violation of a public law forbidding or commanding it. Definition given by Blackstone has been criticized to be too wide as it will include every legal wrong or violation of law. Another definition given by Austin is a wrong which is pursued at the discretion of the injured party and his representatives as a civil injury. A wrong which is pursued by the sovereign or his subordinates as a crime. This definition was observed to be not of substance but of procedure only. Besides, there are several offences which cannot be pursued except by the injured party. Prof. Kenny modifies Austin and defines crime to be wrongs whose sanction is punitive and is in no way remissible by any private person, but is remissible by the Crown alone if remissible at all. This definition is also not without criticism. Prof. Winfield says that definition breaks down on the word remission. He says that only Crown can remit a punishment by pardon, and in English common law only those crimes are pardonable which are against the public laws and statutes of the realm. In India also various offences under Indian Penal Code are compoundable by private individuals even without the intervention of the court. An American author, Miller, has defined crime to be the commission or omission of an act which the law forbids or commands under pain of a punishment to be imposed by the state by a proceeding in its own name. This definition seems to be less open to criticism than others. Prof. Patton observes, in crime we find that the normal marks are that the state has power to control the procedure, to remit the penalty or to inflict the punishment. Prof. Keaton says a crime today would seem to be any undesirable act which the state finds it most convenient to correct by the institution of proceedings for the infliction of a penalty, instead of leaving the remedy to the discretion of some injured person. It can be observed that all attempts to define crime have not been very fruitful. It can only be defined in terms of its attributes. Firstly, it is harm brought about by some antisocial act of a human being, which sovereign power desires to prevent. Secondly, preventive measures taken by the state may be in the form of a threat of a sanction or punishment. And thirdly, wherein guilt of the accused is determined in a special kind of proceedings governed by special rule of evidence. 2.4 Modern approach to crime. The traditional approach to crime had been to formulate a definition of crime. Therefore, all the jurists beginning with Blackstone down to Kenny attempted to define crime, but more or less all of them failed to bring in within the narrow compass of a definition the flexible notion of a crime which is conditioned by the changing moral values and social opinions of the community from time to time. Moreover, the traditional approach to crime suited a society which had not developed into a complex society. Earlier number of crimes were fewer which could be roped in within the four corners of a definition. But with rapid industrialization and means of communications and modern scientific investigations, crime also have taken a new turn. They have not only multiplied in numbers but also have grown more complex, complicated, and even involve a lot of technology and science. Formerly crimes were committed out of greed, lust and land, but now such crimes have relegated to the category of traditional crimes. Modern crimes committed by persons belonging to the higher social status by beguiling people or practicing fraud or misrepresentation or by adopting other known or unknown ways to amass money by fair means or foul have all appeared. Some new categories of crime like cybercrime and theft of intellectual property have appeared too. Therefore, a modern approach to combat such crimes has become absolutely necessary. Defining crime, being a traditional approach, has to be given up. The modern conception is that crime is a public wrong, i.e. a wrong which offends against the public generally. The modern approach is not to bother about a definition of a crime but to lay stress on its functions. In other words, the modern approach is functional approach to the crime. In 1958, the Wolfenden Committee report has spotlighted the functional approach to crime in England and lays down clearly, both positively and negatively, what it should be and what it should not be. It observes that the function of criminal law is To preserve public order and decency, to protect citizens from what is offensive or injurious, and to provide sufficient safeguards against exploitation and corruption of others, particularly those who are young, weak in body or mind, inexperienced, or in a state of physical, official, or economic dependence. By way of explanation, committee itself observed that opinions will differ as to what is offensive or injurious or inimical to the common good, and as to what constitutes exploitation or corruption, and those opinions will be based on the prevailing moral, social, or cultural standards. This explanation fits in with the growing needs of the society. The criminal law will not concern itself with what a man does in private unless it can be shown to be contrary to the public good, that the law ought to intervene in its functions as the guardian of the public good. Private morality or immorality is not the concern of criminal law. It appears we are again reverting to what Blackstone said, that crime is a public wrong because the modern notion of criminal law is concerned with behavior which is normally reprehensible and is inimical to law and order. A search for a definition of crime, being a traditional approach to crime, should now in modern times be given up as being a futile approach, and instead a real search should be for the norms, ethics, and practical expediency. In this sense, it includes violation of conduct norms and social norms. Conduct norms. In this view, popularized by a 1938 book written by Thorstein Sellen, crime is just one form of conduct norm violations. Every group one belongs to, regardless of political boundaries, regardless of embodiment in law, has conduct norms. Norms are the unspoken rules of right, normal, and wrong, abnormal, that are contained in custom, tradition, ethics, religion, family, and other social institutions. Social harm. This view is most closely associated with Sutherland's interests in white-collar crime. To Sutherland, and to most criminologists, it is clearly unfair that white-collar criminals get off with civil fines rather than criminal punishments. Corporations that pollute the environment have to pay $1 million penalty, nothing more than a slap on the wrist to them, while someone who shares a marijuana cigarette with a friend gets 6 years in prison for trafficking. Quite a lengthy restriction of liberty. Criminologists adhering to this sense of unfairness tend to believe that crime is any socially harmful act or analogous social injury, whether legally permissible or not. In this view, crime includes untimely death, illness or disease, deprivation of food, shelter, clothing, medical care, racism, sexism, and tobacco, etc. Human rights violation. This view is most closely associated with the arguments made by Hermann and Julia Schwendinger, although there are other influences. For the Schwendingers, not only anything that causes social injury, imperialism, sexism, racism, poverty, is crime, but also anything that thwarts the right to a dignified human existence, freedom of movement, free speech, a good education, employment, the right to unionize, life, liberty, happiness, and so on. The concept of human rights has the advantage of cutting across cultures and over time. Deviance and social control. The view that crime is deviance or norm-violating behavior is associated most with sociological criminology. The norms can originate from any source: religion, political belief, etiquette, fashion, or criminal law. In fact, deviance occurs whenever there is stigmatization, isolation, rejection, segregation, punishment, treatment, or rehabilitation. Social control can be coercive, forceful, normative, attitudinal, or an exchange solution, sets of rewards and incentives. Not all deviant acts are criminal, and vice versa. Deviance is in the eye of the beholder. Law is but one form of social control, a coercive, governmental solution. The term criminalization refers to the process whereby criminal law is selectively applied to certain behaviors, and many criminalization specialists adhere to a deviance and social control viewpoint, asking the question if criminalization is a neutral process or if it serves the interests of the powerful. Other forms of social control are sometimes studied, like dispute resolution, mediation, therapeutic, counseling, rehabilitation, reconciliation, restitution, self-help, avoidance, negotiation, settlement, and toleration. Deviance and social control specialists tend to focus on distinguishing kinds of acts. Contextual explanations from kinds of people, compositional explanations. Those who adhere to a compositional explanation used to be called social pathologists, and studied the 3Ds, delinquent, defective, and dangerous classes. Social problem. Crime is but one of many enduring conditions that seems to have always been there and show no signs of going away, like homosexuality, teenage pregnancy, poverty, or aging. The social problems approach tries to avoid reductionism or explaining crime by virtue of any one explanation. Biological, psychological, or even sociological. It tends to look at the social meanings or collective definitions of crime. It therefore closely studies things like media polls or public opinion, media portrayals, images of crime, and the measurement of crime are serious concerns to social problem specialists. 2.5 Theoretical approach to crime. It is not only important to define crime but also important to know why crimes are committed and why a person becomes a criminal. Theoretical explanation of crime helps in dealing with crime and criminals have been various things to different people throughout time: heroes, villains, fools, revolutionaries, deviants, scumbags. Most policy making in criminal justice is based on criminological theory. In fact, most of the failed policies in criminal justice are due to misinterpretation, partial implementation, or ignorance of criminological theory. Much time and money could be saved if only policymakers had a thorough understanding of criminological theory. Every criminological theory contains a set of assumptions about human nature, social structure, and the principles of causation, to name a few: a description of the phenomena to be explained, and an explanation or prediction of that phenomenon. Criminological theories are primarily concerned with etiology, the study of causes or reasons for crime, but occasionally have important things to say about actors in the criminal justice system also, such as police, attorneys, correctional personnel, and victims. Some important theoretical approaches are 2.5.1 Individualistic approach to crime. A. Demonological theory. Pre-classical approach. The theory that the crime was the result of a man acting under the influence of and succumbing to the blandishment of evil spirits is perhaps the oldest one. During 17th century, the idea of religion was dominating the social thinking. The views of Saint Thomas Aquinas had a great influence. The monarch was treated as a divine power on the earth, and the human beings were treated as devoid of any power, as they were under the control of some other superspirit. A criminal was regarded under the control of some demon spirit prompting him to do the misdeeds. The criminal was regarded as a depraved person deserving deterrent punishment. B. Free will theory. Classical approach. Beccaria, Bentham, and Romilly are the pioneers of the classical school. According to this school, the man is possessed of free will and he acts on the basis of the pleasure and pain, i.e., hedonism. This school rejected the theory of offenders acting under the influence of some devilish spirit. The punishment is a discouragement to the man to commit the crimes, as there will be no gain by the crime. The state should alone have the power to keep the force in prosecution. By bearing the punishment, the criminal becomes a free man, as by paying the penalty he repurchases his freedom. To Beccaria, basis of the punishment is to restrain the individuals from encroaching upon the freedom of the others which they enjoy by virtue of a social contract. The punishment aims to preserve the existence of the society. The punishment must be prompt and effective, as it is not the cruelty of punishment, but its certainty, so that the accused may not derive any gain by committing the crime. C. Organic deficiency theory. Positivist approach. Cesare Lombroso is the main exponent of this approach. He explained the concept of atavism. 9 Lombroso's general theory suggested that criminals are distinguished from non-criminals by multiple physical anomalies. He postulated that criminals represented a reversion to a primitive or subhuman type of man characterized by physical features reminiscent of apes, lower primates, and early man, and to some extent preserved, he said, in modern savages. The behavior of these biological throwbacks will inevitably be contrary to the rules and expectations of modern civilized society. Through years of post-mortem examinations and anthropometric studies of criminals, the insane, and normal individuals, Lombroso became convinced that the born criminal, Rio Nato, a term given by Ferry, could be anatomically identified by such items as a sloping forehead, ears of unusual size, asymmetry of the face, prognathism, excessive length of arms, asymmetry of the cranium, and other physical stigmata. He believed that specific criminals, such as thieves, rapists, and murderers, could be distinguished by specific characteristics. Lombroso also maintained that criminals had less sensibility to pain and touch, more acute sight, a lack of moral sense, including an absence of remorse, more vanity, impulsiveness, vindictiveness, and cruelty, and other manifestations, such as a special criminal argot and the excessive use of tattooing. Besides the born criminal, Lombroso also described criminaloids, or occasional criminals, criminals by passion, moral imbeciles, and criminal epileptics. Another exponent, Enrico Ferri, accepting the views of Lombroso, gave emphasis on environment also. He described the crimes as the synthetics product of physical or geographical, anthropological and psychological and social factors. According to Ferri, punishment is only one form of influencing behavior, and therefore he laid the emphasis on a detailed crime prevention program by removing those conditions due to which the crime is caused. Ferri described the following kinds of criminals: I. Insane. E. Born. E. Habitual. IV. Passionate. V. Occasional. Professor Ernest A. Houghton said the physical and racial factors as important in the crime. Criminals have inferior physical composition and thus they differ from non-criminals. According to him, the criminal stock needs to be eliminated. The sterilization of defective type of persons and breeding the better race is necessary to check the criminality. The positivists' main contribution is regarding the theories of treatment that they juveniles and adults must be treated in different manner. The execution of sentence of the juveniles and adults has been left to the psychiatrists, criminologists and social workers. Fines, probation and parole as alternatives to incarceration are better. The positivist approach suggests recasting of the role of judiciary. The positivist reformers emphasize separation of guilt determination from the sentence. The former is to be done by a qualified judge while the latter by a social physician. D. Mental deficiency theory. In 1838, Jean Esquirol of France pointed out in his book Mental Diseases the distinction between mental defect and mental disease. The similar view was taken by Isaac Ray in USA, and he raised the question whether the criminal act could be imputed to a man who was incapable of knowing the intent or consequences of the act. The studies made by Richard Dugdale and Henry H. Goddard in some of the alleged mentally retarded families give the impression of a proximity between the mental retardation and the crime. The less intelligent persons can be molded as delinquents or law-abiding persons. Mentally retarded persons easily become criminals. Criminals have also been a more intelligent class as compared to the general public. The serious delinquents have been found not of lower intelligence. Dr. William Healy out of 4,000 case study in Chicago and Boston found 72.5% normal and retarded. In another study of 400 cases of delinquents, only 2 were morons. Distribution of intelligence among criminals was found the same as among the general population in a study by Weiss and Sumpliner. A. Emotional disturbances. The abnormality of mind may occur due to physical and psychological reasons. The physical reasons may be brought about by diseases, toxic or poisonous products in the system. The age factor, malfunctioning of endocrine glands may cause pathological excitability, abnormal apathy, etc. Bicephalous paresis may result affecting motor sensory responses whereby it becomes difficult for an individual to control normally his reflexes. Senility may also affect the normal responses. Physical handicapness may also generate the criminality, but this is not generally true. Majority of the physically handicapped persons adjust them with the norms operating in the society. The criminality in handicapped persons may develop because of certain other factors also when they are not accepted properly by their parents and guardians. The experiences which a man has faced in his life from very childhood may create mental reactions, i.e., complexes, thereby making it difficult for him to face adult responsibilities. Extreme poverty, frustration, insecurity, rejection, failure in love, professional failures and economic conditions may create such problems. Suffering from the mental torture, the individual may tend to escape from the intolerable reality and may live in mental fantasy. Sometimes, such persons may develop aggressiveness and cruelty in behavior. F. Psychoanalytical theory. Sigmund Freud is the propounder of this theory. In committing a crime, the id and ego play important roles. Id is present from the birth. Id is the basic biological and physical urge, e.g. hunger, sex, auction, etc. It always operates in unconscious manner. Ego, a conscious personality for which a man remains aware that only a rightful way if getting these things is proper, otherwise the society will cast aspersion on him. The relationship between id and ego brings out superego, which is a controlling factor of human beings. Thus the superego acts as a self-restraint in every human being. A conflict between id, ego, and superego goes on constantly. Due to weakness or ego, the personality, problems arise resulting in the behaviors that are disapproved by the society. The individualistic approaches to crime have lost much of the credibility with the advent of more sophisticated environmental theories. Their main weakness lies in the fact that they fail to understand that crime represents a socio-cultural phenomenon which is not associated with physical or mental capacities of an individual as such, but their importance lies in the fact that for the first time, attention was paid to the personality of the offender, which laid the foundation of modern criminology. 2.5.2 Environmental approaches to crime. A. Differential association theory. Edwin H. Sutherland presented a theory of differential association in his Introduction to Criminology. Sutherland asserts that the criminal behavior is learnable and learned in interaction with other deviant persons. Through this association, they learn not only techniques of certain crimes, but also specific rationale, motives, and so on. These associations vary in frequency, duration, etc. Differential association theory explains why any individual forwards toward deviant behavior. His assertion is most useful when explaining peer influences among deviant youths, a special mechanism of becoming certain criminal. Sutherland did not mean that mere association with criminals would lead to criminal behavior, but he viewed crime as a consequence of conflicting values. Differential association theory was Sutherland's major sociological contribution to criminology. B. Anomie theory. The term anomie was used by Durkheim. It means the state of normlessness or lack of regulation. The normlessness results in deviant behavior. In the transformation of folk society to the modern one, the groups operating between the individual and the state, e.g., local government, church, etc., lose their significance. The relations of the individual with the state become disorderly for not conforming to the social norms. The rules and regulations do not remain of any importance because of discontinuity between the experience and expectation. Merton, who based his theory on anomie, did not emphasize the anomie as the discontinuity between experience and expectation, but the anomie, he said, are the values and norms of the society which do not suit an individual, creating confusion in him. According to Durkheim, anomie is a temporary feature which emerges in course of society's development, but for Merton, anomie is a permanent feature of all modern industrial societies. Durkheim said anomie only endemic in industrial societies which develops due to economic crises or burgeoning industrialism. See conflict theory. Ralph Dahrendorf's book, Class and Class Conflict in Industrial Society, was published in 1959. He realized that all changes occur due to class conflict and the changes in a revolutionary manner. Dahrendorf did not accept the manifestation of antagonism between the classes as they may vary in their intensity. There may be unrecognized or latent antagonism of different interests, or there may be acute or violent conflicts. In capitalist society, the basis of classification is control over the means of production, but in post-capitalist society, the exercise of authority or exclusion from it is the basis of social classification. Thus the conflict arises due to authority subject relations in different contexts, not because of individual conflict. Those having the authority have the power to dominate, and those not have to accept the commands as they are in subjection. So there are two sets of position, one domination and the other subjection. Every individual is either in a dominating position or in subjection. Dahrendorf has rehabilitated conflict approach for criminologists. In every society, there is a coercion by some or others, and dissent and conflict are normally present in every society. Although Dahrendorf was not concerned with crime problem, yet his thought reoriented criminology in a broader perspective, ending its isolation from social sciences. The conflict approaches of Dahrendorf was also acknowledged by Richard Queeny. The diversity, conflict, coercion, and the change in social order were noted by him. Queeny sought to study the problem of crime and criminality with focus on the conflicts of groups in the context of various institutions, e.g., political, economic, religious, kinship, educational, aid, public. Queeny rejected the pluralistic notion of law as representing the diverse interests, rather the law supported the interests of some only at the expense of others. Walter W. Miller worked on gang delinquency and street corner groups. His work on inner city delinquency problem makes it clear that the cultural transformation is relevant to the modern problems. He has described delinquency as a result of group conflict. There are three groups. One is the law-abiding street corner group, another is the aspiring but conflicted group, and the third is the group which becomes successful in upward aspiring. The group which seeks to aspire but is blocked in its aims gives birth to delinquency. D. Geographical theory. According to geographers, the climate and topography affect human behavior very much. This theory focuses on criminal patterns within particular built environments and analyzes the impacts of these external variables on people's cognitive behavior. Montesquieu said that the criminality was more near the equator and drunkenness more near the poles. Adolf Quetelet, the father of statistics, in his Thermic Law of Crime said that in the countries with warm climate, the crimes of human violence were more in number, while in the cold countries, the crimes against property were more in number. The crime rates variation according to the weather, months, north and south, cold and warm. Rural and urban areas have also been noted. The environmental approach was developed in the 1980s by Paul and Patricia Brantingham, putting focus on environmental or context factors that can influence criminal activity. These include space, geography, time, law, offender, and target or victim. These 5 components are a necessary and sufficient condition, for without one, the other 4, even together, will not constitute a criminal incident. A. Economic theory. Economic factors are related to the crime. People in the society are seen to strive for the material goal to meet out their basic needs. The income which is not proportionate to the basic needs of man, or the income which is less than that of which a man is accustomed, or the income which is not to the level of others, is the cause of dissatisfaction. The materialism is the main cause of dissatisfaction. Satisfaction as the highest wealth is no more true due to materialistic attractions. The deviation from the sacred path is leading to criminalistic activities. The white-collar criminals are mainly the effects of degradation of values in the society. Unemployment is also a factor for crimes relating to property, even involving violence. Although the poverty is one of the causes of the crime, yet the crimes are increasing even in those countries which are prosperous. Karl Marx described the law violations generally, the offspring of the economical agencies beyond the control of the legislation. William Bonger, the Dutch criminologist, William Bonger, known as father of conflict criminology, said that the enactment of the law is according to the wishes of the ruling class. The division is the result of the production system. The capitalist system generates egoism instead of altruism, and the criminal tendencies develop in all. Since the egoistic tendencies of the bourgeoisie are legitimized, they are more criminals than the proletariats. The bourgeoisie need not steal since they have lucrative and surer means of gaining money. The proletariats have underdeveloped moral sense, they commit the crime whenever they get the opportunity to gain. Bonger stressed on the poverty as a motivating factor of crime in a capitalistic structure of the society, and excessive alcoholic use by the poor resulting the crime more in number. According to a study made by Dr. Cyril Burt in London, 19% of the delinquent children came from the very poor families and 37% from moderately poor, when the total population of very poor was 8% and moderately poor 22%. The total delinquency was over 50% from the very poor and moderately poor families. The most of delinquents from the comfortable class succeed in avoiding official inquiry. The majority of the needy do not become delinquents, and therefore the majority of the delinquents are not needy. It has been found in USA that many girls adopt prostitution because they want to live in luxurious way, and the boys resort to criminal tendencies because they want to have automobiles, or they desire to keep sex relations with the young girls under the influence of money. F. Social disorganization theory. The society is not static. With the changes in society, the values also change. The urbanization and industrialization have accelerated the dynamic nature of the society. The persons of different races, cultures, religions, and communities come in contact with one another, resulting in breakdown of traditional patterns of living and values. The family attitude has changed into individualistic attitude. It is social disorganization which creates deviant behaviors. Sometimes some components of one culture go ahead of others. Sometimes values are imposed by the government on the traditional values, and sometimes the values are imported. All these things create the problem of social disorganization and therefore delinquency. G. Ethnic theory. The ethnic causes are also important in creating the criminal behaviors. Various races with difference in their cultures lead to conflict amongst themselves because of non-adjustment, underrating one another. The local race tries to subjugate the migrants. The denial of equality of opportunity and subordinate status to Negroes by the whites in the American society has resulted in a lot of discrimination, generating a sense of revolt against the whites and sometimes revolt in their own community by Negroes. In India also the racial discrimination has been a vital factor. Post-independence India has witnessed several sectarian riots leading to bloodshed and anarchy in the various parts of the country, which are glaring examples of it. H. Juvenile gang delinquency theory. According to Frederick M. Thrasher, juvenile delinquents belong more to lower class A, the juveniles in the poverty belt. The poverty is the cause of delinquency. According to Albert K. Cohen, there is a peculiar culture in America, delinquent subculture. The members of this class have some expectations and ambitions. Because the boys of this class find themselves having not the advantages of the same standard as the boys of the middle class society. The delinquency may be caused due to family atmosphere, school atmosphere, economic factors, mass communication media etc. Home and community influence theory. Home and community atmosphere influence the children and their behavior. The loose control, the lack of parental insights, low income, poverty, poor housing, high rental houses and overcrowding of the population, etc., are responsible for criminal behavior in the children. It has been seen that the parents living in strained relations or behaving indecently influence the tender mind of their children. The broken homes where parents live separately or who are divorced, or where one of the parents is fail to provide the natural love and affection and careful attention to the children. These things create problems and the children become delinquents. There are secondary community influences also which mold the behavior of the children. The role of the school, the company in which the child moves, the games which he enjoys, the motion pictures, television and radio all have important roles to play. The sex and pornographic advertisements add to the sensations of the children, causing them delinquency. The roles of the criminals and their activities in the movies leave a very bad impact on the young susceptible to mental affliction. Multiple causation theory. The cause of the crime cannot be attributed to any particular factor. Crime is committed due to various reasons. The theories discussed herein before lead us to the different causes of crime. Enrico Ferri classified the factors of the crime as individual or anthropological, physical or natural and social, the age, sex, civil status, profession, domicile, social rank, instruction, education and the organic constitution are the anthropological factors. The race, climate, fertility, meteoric conditions and temperature are the physical factors. The density of population, emigration, public opinion, customs and religion, public order, economic and industrial conditions, agricultural and industrial production, public administration, of public safety, public instruction and education, public beneficiaries, and in general, civil and penal legislations are the social factors. Ferri, however, said that to these factors we could add many more as it might not be exhaustive list. On a true analysis we end that the crimes are caused due to variety of factors. The white-collar crimes and the crimes involving violence are the two different things and their causes are different. The white-collar crimes are committed more due to greed than the need. The crimes involving violence may be committed due to many reasons, sometimes due to sudden impulse, sometimes due to revengeful attitude, sometimes due to greed of inheriting the property, sometimes due to gratifying sexual lust, etc. Sheldon and Eleanor Gluck in Prof. Wold are also supporters of multiple causation approach. 2.6 Punitive approach to crime. Punitive approach is very traditional approach to crime, which is universal in nature. It regards the criminal as a basically bad and dangerous sort of person. The object of this approach is to punish the offender so that the society may be saved from his misdeeds. The punitive approach has its focus of attention on the damage caused to the victim and danger posed to society. The criminal is treated as something incapable of being reformed. He is judged on the basis of his past conduct and not on what improvements he is capable of in future. This approach, even today, is recognized as a potent force to contain the crime. According to Donald R. Crassi, justification for punitive approach to crime lies in the fact that the criminal is made a scapegoat to give relief or gratification to the members of the community. He is of the view that this relief or gratification is due to their sense of freedom from their own guilt feelings about the crime, as a result of punishment given to the offender. This is based on the theory that all human beings have criminal propensities, though in most cases they may not be reflected in actual behavior. If no outlet is provided to such feelings by punishment, even lynching may be resorted to by the people. Another view is that the hostile reaction to the criminal works as a bond between non-criminal members of the community. The bond represents the reassertion of moral principles common to the members of the society and serves as a reminder of the taboos to all of them. The justification for the punitive approach to crime is also offered on the ground of grim necessity. The pure and extreme retributionists perceive punishment as inherently good, i.e. per se, and believe that no justification is required for punishing an offender. Justification for punitive approach is also argued on the basis of social contract, which creates a situation of give and take. In order to enjoy individual rights and liberties, it is only reasonable and inevitable that individuals curtail their freedom vis-a-vis others, and in case of their failure to do so, punishment must be inflicted on them. In brief, punitive approach may be divided into two classes on the basis of retributive and utilitarian theories. While the retributionists assert that the infliction of punishment is justified in itself since offenders should be given their just due, the utilitarians regard punishment as an evil which should be used only if it serves some real purpose, like deterrence from the commission of crime. 29. In olden days, man has devised a great variety of methods for the punishment of criminals. The most common ones have been death, physical torture, mutilation, branding, public humiliation, fines, forfeiture of property, banishment, transportation, and imprisonment, but each of these had many forms. Thus death has been accomplished by flaying, crucifixion, beheading, hanging, impaling, drowning and burning; physical torture by flogging, dismemberment, and starvation; public humiliation by stocks, pillory, ducking, stools, banks, and branding; and imprisonment by confinement in dungeons, galleys, hulks, jails, houses of correction, workhouses, and penitentiaries. A few of these, however, have survived in modern society, and during the past few decades in Western civilization, the principal methods of punishment have been death, whipping, transportation, fines, restitution, imprisonment, probation, and parole. In modern society, punishment is the penalty inflicted by the state upon a person adjudged guilty of crime. Its administration always involves the intention to produce some kind of pain, which is justified in terms of its assumed values. The pain intended may be partly physical, as in a whipping, but today most methods of punishment are designed primarily to cause mental suffering, as in imprisonment, where there is loss of freedom, reputation, and perhaps of the property. Under Indian Penal Code Section 53, the offenders may be subjected to following types of punishments: 1. Death. 2. Imprisonment for life. 3. Imprisonment which may be a. simple, b. rigorous. 4. Forfeiture of property. 5. Fine. 2.7 Therapeutic approach to crime. Therapeutic approach to crime is of relatively recent origin, which considers the criminal as a victim of circumstances and a product of various factors within the criminal and society. With growing humanitarianism, increasing impersonality in social relationships, and growing belief in the powers of science, capital and corporal penalties have become unacceptable and ineffective and have been largely replaced with imprisonment, probation, and parole. Since this approach regards the criminal as sick person requiring treatment, it is termed as the therapeutic approach. The ultimate objective of the therapeutic approach or correctional administration is the rehabilitation of offenders in the mainstream of social life. The person in a prison is often a victim of circumstances, and his detention period needs to be utilized for giving him training and equipping him with skills which would help him to rehabilitate himself in the society. 30 The modern theory of reformation and rehabilitation emphasizes the need for training not only in custodial and security aspects, but also in the scientific methods of treatment of offenders. Therefore, today jails are not penitentiaries but reformation houses. Sri Sri Ravi Shankar is of the view that expand your vision and see that inside every culprit is a victim crying for help. If you heal the victim, you will eliminate crime from the planet. Prisoners are provided with an opportunity to integrate into the mainstream society and heal themselves. Various programs run in the prison features self-development workshops with an emphasis on human values and vocational training programs. In India, the prisoner rehabilitation program was initiated in 1999 in Tihar Jail, home to some of India's most notorious criminals. The program is active in 8 of the 17 jails in Tihar, and more than 30,000 inmates have participated in the programs and benefited from it. A program Srijan, social rehabilitation of inmates in jail and aiding the needy, has been initiated in some of the jails of India, which offers inmates a variety of opportunities such as theatre, music and dance workshops, and personality development. The initiative also offers vocational training in commercial arts, costume jewelry, fashion, technology, and weaving. 3 Srijan workshops were recently held in New Delhi, where inmates were trained to produce items such as office stationery, gift boxes, and lampshades. The prison administration works with local NGOs and partners to market handicrafts prepared by prisoners in India and abroad. All proceeds go to the craftsmen, thus making them economically independent. It is giving these people the skill to live, support themselves, and develop a lifestyle which is fitting to live in society. Probation and parole also have the objective of rehabilitation of offenders and protection of society from his actions at the same time. In both the techniques, skillful supervision of selected offenders is involved outside the prisons. The advantages of probation and parole have been mentioned in terms of protection of the offender's personality from the contaminating influence of prison life. The released offender has the advantage of continuing to have normal social relationships and his employment. The offender is also spared of the stigma of a prison sentence, making the task of rehabilitation easier. It is also pointed out that unlike the dependents of an offender sent to prison, the dependents of a probationer do not have to be supported by welfare agencies. Probation and parole have great therapeutic value for the offenders as well as for a country like India, where the jails are often overcrowded with frequent human rights violations which would harden the human inside a person. Release of offenders on probation or parole reaffirms the fact that in every individual resides a human being which should be given prominence to. Another important aspect of therapeutic approach to crime is to ensure justice to the victims. Now it is being realized that the victim should also be given substantial right to participate in the criminal proceedings. Therefore, criminal justice system must focus on the right of the victim to participate in cases involving serious crimes and to adequate compensation. Various reports of Law Commission of India 3-1 as well of Committees on Reforms of Criminal Justice Administration 32 have played a pivotal role in developing compensatory jurisprudence in India. The Law Commission of India in its hitherto submitted reports on the Indian Penal Code 1860, IPC, and the Code of Criminal Procedure 1898 and of 1973 has deliberated upon the issue of justice to victims of crime and has also suggested some proposals for reform. The MLE Committee 2003 on reforms of criminal justice system in India has also laid emphasis on the participation of victims in the criminal justice processes and has advocated for compensation and restitution of the victims. 2.8 Preventive approach to crime. Prevention is always better than cure. Prevention of crime and delinquency, like any other phenomenon of an unpleasant and destructive nature, is much better than their subsequent control when they occur. When an offender is sent behind bars or is given capital punishment, he is prevented from committing further crimes during the period of his incarceration or forever. As the case may be, two methods of reducing the frequency of crimes have been suggested and tried. One method aims at reducing the amount of repeated crime, the other at forestalling commission of first crimes. The name, crime prevention, has been given to both methods. Programs for the prevention of crime and delinquency are to be directed not only to those who have already indulged in criminal behavior sufficient enough to warrant cognizance by law enforcement authorities, but also to those who either have manifested some tendency to suggest possible delinquency by them in future or who may be otherwise normal but because of individual or environmental factors operating against them, criminal or delinquent behavior can be expected from them. Preventive approach to crime is more relevant and useful with regard to young persons in view of the fact that the chances of a person turning criminal after reaching a certain age, when the values and attitudes are more or less fixed, are somewhat lower than in the case of persons of immature age and understanding. 33. Though punishment is one method of building up anti-criminal attitudes in the general public, it is not the most efficient method for preventing crime. Preventive approach to crime, instead of focusing attention on particular offenders, seeks to eliminate those conditions which are responsible for the causation of crime. The development of habits and attitudes by education, by the spreading of traditions, by the contacts and interactions between those who appreciate the values and those who do not, is probably a more efficient method. In other words, prevention in this sense includes the efforts to improve family relationship, promote better adjustments in school, provision of education and recreation, designed to produce useful and upright citizens, and the use of aids in the fields of social work, medicine and psychiatry. As we find out more about crime causation, we shall have a better basis for the determination of specific policies for this purpose. These policies, if carried out consistently, may be expected to protect society from crime in three ways. 1. First, they would secure a relatively permanent segregation or gross lack of appreciation of conventional values or social situations and constitute the greatest menace to the group. 2. Second, these policies would restore to society without alienating them a large proportion of those who have not definitely broken away from the general anti-criminal culture of the organized society. 3. Third, these policies would define the type of personality and the social situations from which crimes are most likely to issue, and would make it possible to deal with such persons in advance of crime and to attack and eliminate those social situations. Thus, protection against crime would be secured by modifying those who could be modified by available techniques, segregating those who could not be so modified, and correcting or segregating in advance of crime those who were proved to be most likely to commit crime, and attacking and eliminating the social situations which were most conducive to crime. Such policies would be as much evidence that the organized society disapproved of crime as would punishment, and it is this disapprobation, rather than punishment of individual criminals, which tends to deter the large majority of the population from crime. 2.9 Summary. Crime is an act which is both forbidden by law and revolting to the moral sentiments of the society. Crime is a relative concept and a changing one too. Approaches to crime have been different at different stages of human civilization, and even at a given time they have been different in various societies. Traditional approach defines crime in terms of violation of public law, whereas modern approach to crime emphasizes upon functional aspect of law. Theoretical explanation to crime involves individualistic and environmental approaches to crime. Crime may be defined in terms of its attributes and characteristics by first distinguishing crime from civil and moral wrong, and secondly by critically examining definitions given by eminent criminal jurists from time to time. If the law awards a punishment for the wrong done, we call it a crime, but if law does not consider it serious enough to award a punishment and allows only indemnification or damage, we call such wrong as a civil wrong or tort. It is not only important to define crime but also important to know why crimes are committed and why a person becomes a criminal. Theoretical explanation of crime helps in dealing with crime and criminal. Individualistic approach to the crime for the first time paid attention to the personality of the offender, which laid the foundation of modern criminology. Environmental approach to crime represents a socio-cultural phenomenon, which is not associated with physical or mental capacities of an individual. As such, punitive approach is very traditional approach to crime, which is universal in nature. It regards the criminal as a basically bad and dangerous sort of person. The object of this approach is to punish the offender so that the society may be saved from his misdeeds. Therapeutic approach to crime is of relatively recent origin, which considers the criminal as a victim of circumstances and a product of various factors within the criminal and society. It regards the criminal as sick person requiring treatment. Prevention of crime and delinquency, like any other phenomenon of an unpleasant and destructive nature, is much better than their subsequent control. When they occur, programs for the prevention of crime and delinquency are to be directed not only to those who have already indulged in criminal behavior but also towards potential criminals and delinquents. Different approaches to crime provide better basis for the determination of specific policies for dealing with crime and criminals. Thank you.